This meeting is being recorded.
Thanks so much for joining us. This has been pre-recorded. There was a scheduling conflict that had risen, so Ironwood was kind enough to coordinate this ahead of time, and I'll be sharing this with everyone. But thanks so much for joining us whenever you are joining us. I can't believe here we are, 2023. Wow. But I'm going to kick things off with Amanda and Mitch here. And Amanda is going to be speaking on New Year compliance checklist and what needs to be being accomplished here in first quarter. So thanks for joining us, guys. And I'm going to hand it over to you, Amanda.
Elizabeth. Well, I'm with Elizabeth. I can't believe that it's a new year in January already. But as she mentioned, the first thing we're going to talk about today is just a New Year's compliance check-in. I will say on the front end today, some of the things I'm going to mention, because I'm going to go through a whole list, may not apply to you. That may make you feel better or worse, depending on how you look at it. It's less homework to think about. So think of it that way, even though as I'm going through everything. So the first thing you should think about checking in on are your compliance posters. So think about those things that are either in your break room. Some people have them online if you have a more remote work site. Some people might have them physically out at all of the jobs sites. This is a good time to go in and audit and make sure that you have everything that's required. There are both state and federal requirements there. And honestly, the Department of Labor has an excellent resource for you. It's a poster questionnaire that you can go to. It will walk you through. I actually redid it this morning just to be a little more familiar with it before talking to you guys about it. But it's so specific. It's going to ask you state, it's going to ask you size, but then it's really even going to get into your business as far as what you specialize in, whether you have unions. There are about 10, 15 questions there at the beginning that really get specific, so that by the time it comes through with your answer, which even with 10 or 15 questions, it takes like 3 minutes. They're yes or no. Then it gives you the recommendations and links to the posters that you have to have posted. So even if you're just doing a double check, you could go through that and then have the copies of the pictures and then go and look and make sure that you have one of all of them, or one of those combined posters if that's what you prefer. As long as they are posted, you are in good shape. I will say that the one thing that I always joke about when I am new to a work site, it always seemed like I would go to the different locations, and when you go to their poster area, again, I'm saying break room, but it could be any place that employees normally are. I am always shocked to see like 10 more posters than they actually need. And I totally get it, because someone is just trying to make sure they have all of the right things up there. And it's not even like they have extra posters that aren't relevant. A lot of times there's just previous versions of the poster that's hanging there. So there's no need to have more than one version of the poster. If you have more than one, just make sure you have the most recent version. And if you have one of those larger signs that has 6 or 8 different posters on there, that works too. Of course, you just want to make sure it's big enough that people can read it, but they normally are. You don't have to have that individual poster off to the side. So there's no reason to duplicate. You do want to keep in mind all of your workforce. So it might be possible that you have some, like I said, on a job site and a break room. You might have an online bulletin board as well, just depending on whether your employees are remote, if they're out in the field, or if they are in an office. But again, Department of Labor has a poster questionnaire. And if you guys will remember from last year, there was actually a new poster that came out in November. I don't have the date, but end of the year, it was a Know Your Rights poster. It was about discrimination and harassment, EEO. And we actually talked about it on Clear Up the Chaos, but that is one for sure that's changed. For most of us, there shouldn't be any other big changes here in Texas, but again, it can vary company to company. So I do really recommend going in and checking. A lot of times too, you have to have that workers' comp poster. And if you don't have a copy of that, another place I would suggest looking is the Texas Workforce Commission. They have all of the state posters here for Texas. If you do operate in other states, I do highly recommend that you go to their state websites and make sure that you are fully in compliance with all of the different regulations, even city to city, state to state. Sometimes you have other requirements there. Again, that's one that won't affect probably most of us, but as your business has grown and expanded, especially if you're thinking about the prior year, oh, we weren't working in XYZ states and now we are. Make sure that you are meeting all of their requirements as well. Second thing to go and look at is your handbook. Now, I feel like we mention handbook just about every time, and that can seem a bit daunting, I know, because it's probably anywhere from 30 to 50 pages long on average, and it can be a lot to sit down and go through every policy. Now, in general, I recommend doing a really deep dive into that every other year. Now, you didn't just hear me give you permission to not look at it at the beginning of the year, or to not go in and make sure your policies are working for you, especially if you hear about a new piece of legislation, or if we share something with you, or through any of your other resources. Of course, if it's a big company change, you'll need to make updates mid-year, but I suggest reading through it every year, see what's working for you and what's not. If there is a policy that is absolutely not something you're following and not something you can follow, it's okay to make changes as long as you are staying in the spirit of the regulation and following that. But it's got to be something realistic for you. And my bet is, if it's something that's come up in the last year, you've identified the holes in your policy yourselves. But again, a really deep dive, I would say at least every other year, just with all of the different ongoing regulations and changes, you know, things as simple as back in 2021 in Texas, the definition of sexual harassment changed. That's something where, you know, if you're quickly going through your policies, you may not have gone through and updated that specific language. Well, now would be the time to do that if not. And so handbooks overall, again, I know it can be a bit daunting, but even if you have to chunk it out and do it a little bit at a time, that's okay too. Just get started on it. You know, no one is saying that you have to have that, you know, done by the end of January, but just get to work on it. And if you have questions about it, that's what we're here for. Third thing I would say here at the beginning of the year is your I-9 maintenance. So it's been quite a while since we've talked about I-9. So a couple of things I want to touch base with you on this about. One is, if those are not separate from your other employee files, this might be a good project for the beginning of the year. And maybe it's, you know, when you have a slow day or at the end of the day, this is something you could do in pieces. But you do want to keep those I-9s separate from the full employee file, whether they are paper files or whether that is digital. If it's digital, you just want to have a separate I-9 folder for your employees. And if you keep copies of your driver's license, socials, passport, whatever the employment authorization documents were, you keep those with that separate folder as well. So it's the start of a new year. If you have yours filed by year, because if you'll remember, there are timelines on there as far as retention periods, and a lot of times it's 3 years from the date of separation. It can actually be based on the date of hire as well. It's just less common. So again, the specifics we're happy to go through with you. But if you already have a system set up, whether that's by month or by year, it might be time to go in and purge those out for the year. And then of course you want to make sure that you are shredding those, or you are making sure that your documents are secure and handled either through an outside company or through your internal procedures, because of course that's really important that you keep their employees' privacy up to date and protect all of your information. But it's a good time to go through and pull all of the I-9s. Let's say you did have them still in the files, and let's say you didn't pull your terminated employees out. Now's a good time to go through and make sure, okay, who do I have in my active employee file? Who do I have in my terminated file? If they're in the terminated and my I-9 isn't separate yet, let's go ahead and pull that over and make sure that that's filed. Again, you might do it fully by year. A lot of times you see month and year, and then you can purge those as you go, to meet the requirement. And when in doubt, it's actually there on the bottom of the I-9 itself. It actually gives you the actual retention period there. Because again, there's a couple of different ways you can look at it, by hire date or by term date. Another little thing there, why we're just talking about I-9s though, again, if you'll remember last fall, we were reminding you that at the bottom of that I-9 document, it says that it expired on October 31st, 2022. Now, this is one time where you're not behind if you haven't made that change yet. The government is behind. Maybe that's not so unusual, but the new version of the I-9 has not been released yet. So that one that still says October 31st, 2022 expiration is still the correct one to use. We are expecting that new version to come out first quarter. But of course, that's something that we would share with you guys as it came out. And again, we talked last year a little bit about some of the anticipated changes, but when that comes through, that's surely something we'll touch base on with you guys. So another thing to be thinking about while we're on paperwork is your tax withholdings. Again, this may not be your direct responsibility, but maybe you're partnering with payroll to make sure you've got all of the information you need for your W-2s. If you've got 1099s and W-9s, make sure you have all of your addresses in order so that you're ready for the end of this month. Another good thing to keep in mind, we were just talking about paperwork, but if you've got that new hire packet out, or if you're in that file digitally, it's a good time to go ahead and pull your 2022 W-4s. So what I'm talking about here is the blank form in the new hire packet. You don't have to go through and remove from the file, but replace that with the 2023 version. There are some minor changes made with it, but there's also an instruction sheet with it that you can use. So it's a good time to just switch that packet out and make sure that you are up to date there. So now we're going to get into the ones that may or may not apply to you. Again, where you have to break down is really what states do I operate in? Where do my employees live? If you aren't really sure of that, I would run a report and make sure you have that information so that you know that you're meeting not only the federal regulations, but also the state ones. And that's because number 5 is minimum wage increases. So again, here in Texas, there have not been any changes. So don't panic about anything there. You're not behind the 8 ball there, but there have been some changes in other states and actually even in some other cities. So if you have a workforce that is spread out, or if you work in different areas of the country, that would be something that I would recommend going in and looking just to make sure that you're online and meeting all of those local and state laws as well. If that wage did change somewhere for you, that is a poster that would have to be updated. So right now, the one in Texas has not changed in several years, more than a dozen years. So again, you don't have to worry right now in Texas. The only poster change, like we talked about earlier, was that Know Your Rights poster from back in the fall. But if you do operate in other cities and states, that would be a good time to go in and check and make sure you have that right poster. And of course, you can go to those state websites and check on those. And again, a few cities have their own laws, so keep that in mind as well. Especially if you're aware, several different states and cities are stair-stepping their minimum wage. So you may see small changes over the next several years. So that's something to just watch out for. Again, that's not going to apply to most of us, but it's a good time to just make sure you've got that minimum wage poster up and go through your compensation spreadsheets and just make sure everybody's rate is accurate, especially if you have some of those special circumstances where I'm thinking restaurant industry where the hourly rate is different, or if you've got gig workers. It's just a really good time to go through and look at all of your processes and procedures and make sure you're hitting all of those minimum requirements. So the 6th one that we're going to talk about is exempt salary threshold. Okay, now every month we've touched base on this, and the only real news that I have here is there's no new news. We expected this, goodness, back last May, June, and the federal level has not ever come out. We have not gotten any proposed changes. We did see an article actually just this morning, it's been pretty quiet, that said that May is the new target date. But again, last May was the original target date. So we don't have the exact date there that we're going to need to look at that. Even when it does come out, don't worry, you're going to have plenty of notice. It's going to be a proposed change. There's likely going to be back and forth on the actual dollar amount. We're going to have some time to go through not only the actual salary amount, but any of the duty requirements if those end up updating. But all that being said, just like the minimum wage might have changed in some states or in some cities, if you have employees working, especially in some of those more employee-friendly states or cities, it's a good time just to make sure that you're hitting all of your salary thresholds and that you're hitting that minimum wage, exempt minimum salary requirements. If you're there and you are starting to get nervous about these changes for exempt salary, it is another time that if you didn't think about it last year, that you could start to look at, who would it affect if we go from $38,000, $39,000 as the lowest amount of money you can make for salary? If that were to go up to 48, 50,000, again, we don't know what number it's going to be. That's just the estimates, and what the articles are predicting is as high as it would go. Who would this affect? What would we do as a company? Would we just have overtime? Would we change these people's salaries? It doesn't hurt to start thinking about those things if you haven't yet. But again, don't panic about it. You're going to have plenty of time once the actual proposed legislation comes out to think through those changes and to talk through those changes. Another area to keep in mind that you want to check in on is any leave policies. Again, here in Texas, here in the same thing as the last two that we've talked about, there have not been any significant changes as far as any vacation requirements, PTO requirements. Nothing has changed here at the state level. I say that, and if anybody today is visiting with us or watching from New Mexico, or if you operate in New Mexico, no changes as of January 1st, but if you did not make updates when their new sick time law went into effect last July, now is going to be a good time to go in there and make sure that your existing policy complies with New Mexico laws. Again, that's just for those that either operate in New Mexico or have employees working in the state. So for sure, New Mexico employers want to go in and check on that. Texas, we're okay for now, but when you're in there looking through your handbook, it's a good time to think, do we have all of the types of leave in place that might come up? If we're over 50 employees, do we have an FMLA leave policy in there? If you're under that amount, or let's even say you're over, but your employees are spread out, and you don't meet that FMLA requirement, do we have some sort of unpaid personal leave or personal leave policy? If you've got that personal leave policy, how long does someone have to be with the company before they can apply for? How long could they possibly be out? Think through those things. So again, just a good time to look at that. No major changes at the state or federal level right now, but look at that. Look at your bereavement policy, look at your voting policy. No changes, but jury duty, that's another type of leave, your PTO. Are these things working for us? Do we need to make any changes? Now, another area that has actually changed that you'll want to update is the IRS's recommended mileage reimbursement. Now, a couple of things with this. This did change middle of the year last year. It went up to 62.5 cents per mile. That's a bit unusual. Normally, the IRS sets this recommendation for mileage reimbursement in the fall, and it stays for that for the whole next calendar year. To go through and adjust for some of the price increases in gas last year, that's why that was raised mid-year. But it did actually go up again as of January 1st. So that recommended reimbursement rate for mileage is now 65.5 cents. And that information just came out. Now, keep in mind, this rate is just a recommendation, and you're going to want to look at your actual mileage policies if you have employees that drive on your behalf, non-DOT vehicles, and go through and see. But if you are using that IRS rate, or if your policy was written to the IRS rate, you do want to go through and update, and you set 65.5 cents for 2023. Okay, powering through, not much left on the list. I know it's been a lot. Compensation audits. So again, here in Texas, we have not had any big changes as far as pay transparency. You've heard a lot of that on the news about having to post your salary or your hourly wage requirement with job listings. Nothing has changed here in Texas. I do like to touch on this though, because when we hear about that in so many other states, like we have this year, it's again something to start thinking about. If we had to do this, are we happy with our pay ranges? Have we done a market audit? Have we analyzed this recently? Do we feel like if we did have to be transparent about this, that we would have any liabilities as far as equal pay? If you are going through and doing a fully comprehensive compensation audit, you will again want to make sure your job descriptions are up to date, your job titles are up to date. A lot of people like to say, well, we don't really care about titles here. They're not important. And I 100% understand that philosophy. But at one place where it is important, even if it's just in the computer system, is for things like compensation audits, because you want to make sure you have some sort of system for each job category, for each job title. So again, no major changes at the state or federal level for us, but it is a good time if you didn't do it last year to go in and review and see that you do have a system in place. If you don't have a compensation policy or compensation philosophy, it's a good time to go through and try to put something together for the year. If you are working again or recruiting from out of state, you will want to be familiar, because several states have put in that requirement for pay transparency and for posting the actual job ranges or the hourly rate. So be aware of where you're posting and whether or not those would be applied to you. Last but very not least, kind of ties into compensation, but performance review and merit increases. So a lot of you guys probably did performance reviews at the end of last year to try to wrap everything up. It's a good time to go in and make sure any merit changes or end of year bonuses made it into the payroll system if they're coming out, that any of those rate changes have gone through, and that you have the documentation to back that up, and why some people got rate increases at one amount and some people got another. It's also just a good time, if you didn't do the performance reviews last year, if you didn't finish them up, to do your goal setting for the year, meeting with your employees, celebrate their successes, focus on what they want to learn and develop in 2023, and share what you as the supervisor want them to develop, how you want the department to develop. If you are able and feel like you can share with them your own personal goals for the year, that's just another way you guys can work to support each other. So I know that that was a very long list, and you feel like you probably have a lot of homework, but remember, not all of those apply to everyone. And there's probably not too many things that you're not already doing. This is mostly going in and double checking and making sure there's no changes and that what was present is working for you. So if you have any questions about that, of course, we're always here if you want to reach out. But for now, I'm going to pass it to Mitch, and he's going to talk a little bit about your proactive HR.
Thanks, Amanda. So what we've covered, if you've been tuning in over the last couple of months, multiple ways that HR can react to various situations after they've occurred. But with January being the time that many companies start planning for the future, we wanted to show that HR isn't just limited to being reactive, but that being proactive can actually help address issues before they occur, which will save time, money, and countless headaches. So one of the first considerations is not only to understand the regulations and laws affecting the company currently. Amanda did an excellent job of covering those just now, but you'll also want to take a look at some of the policies that may come into play as the company grows. So for example, based on company size, there are actually different laws that come into play. So for 10 employees, that's when most companies will have to start their OSHA record keeping. At 15, that's when things like the Americans with Disabilities Act, the Pregnancy Discrimination Act, GINA, which covers genetic information for employment and health insurance, and then Title VII, which is sexual harassment, comes into play. At 20 employees, that's when you'll see the Age Discrimination and Employment Act come into play, COBRA, which covers continuation of health benefits. At 50 employees, that's FMLA, the ACA, which comes into play. At 50, if you are a federal contractor, that's also when you'd have to start doing your EEO1 reporting, which is submitting demographic data. And then if you get up over 100 employees, that's when the WARN Act, which helps cover layoffs and notifications, as well as the EEO1 reporting for all companies, not just federal contractors. So as the company grows, this might necessitate developing policies or adjusting existing policies to reflect these changes. You may also need to create procedures to address the reporting aspects. But by being aware of these potential changes, you can then proactively work to have a plan in place, as opposed to scrambling the first time an employee goes out on a medical leave once FMLA becomes applicable. It's always a good idea to keep an eye out for any rule changes that might impact the company as well. So like Amanda covered, the DOL announcement that was anticipated in last June, then October, now it's been pushed to May. So it's a good idea to just be mindful of those. That way, as more information starts coming out, you can start planning accordingly. But being proactive isn't just limited to upcoming regulations. So with regards to policies, think about the issues that have arisen where a policy was unclear and the issues it caused. A common one I've seen, I've had quite a few calls on it recently actually, is not having a clearly defined personal leave policy. By not including a maximum duration, it becomes unclear what the expectations are of the employee and when the company can look to separate. However, by taking the time to define this, the company has a potential guideline to mitigate confusion. So trying to establish those strong policies ahead of time can be an easy way to provide a framework for the future. That said, proactive HR isn't just limited to policies and regulations either. Let's say hypothetically, the company's goal for the next year is just increase revenue. How do you get there? What resources are available? How can you measure your successes? By understanding the overall goal, you can begin to develop strategies for the company to get there and ways to measure the effectiveness of meeting those goals. So using this example, you might need to look at whether the current workforce has the capacity to increase productivity through training or changes in technology, or if you need to expand your workforce to meet these objectives. This may mean investing in training, new equipment, or the hiring of additional employees. So one good way you can prepare for that is a SWOT analysis. So it's looking at your strengths, weaknesses, opportunities, and threats. That can help you better identify the areas the company is succeeding in, as well as areas that could be improved upon or other external factors. And then you want to have a plan for measuring progress. Things like revenue and attrition, I mean, they're pretty transparent. Things like employee satisfaction, that's not as easy to measure. But trying to take some time to determine how progress could be measured and tracked. So looking at things like work quantity, efficiency, quality, or attendance. Those are relatively easy to track and they can provide a benchmark for future performance. In the long run, you can look at the data and make informed personnel decisions and better assess how to approach a given employee. From there, once you've identified potential areas for growth and a way to measure, determine a pathway forward. If it's something where you're looking at adding headcount, take the time to look at the skill set you'll need for a given role and the potential impact that may have on an organizational structure. So if you're looking at adding 15 new employees, you may need to look at a supervisor or manager to try and make sure that you can properly oversee that new team. If you're looking for a rock star individual contributor, that job search will also look different than an entry-level grunt or a manager. From there, it's a good idea to start looking at market trends, analyzing salaries, and updating those job descriptions so that you can clearly define what you're looking for, and that'll make a positive impact on your candidate search. Another good thing when you're looking at the market analysis is being mindful of the salaries. If you're offering 20K less than your competitors, you might have a harder time drawing in those experienced candidates that are more aware of their worth. That said, if you're willing to take somebody at a lower salary, you may need to make sure that you have a structure in place to help develop and mold those candidates. Keep in mind that external postings can also have an impact on employee satisfaction. One that I used to see quite a bit is we were posting externally at pretty high rate compared to what the current employees were making. The current employees would see that and go, hey, I should be paid more. The new guy's getting paid more than I am, which can kind of impact morale a little bit, can lead people to looking external. So it's always a good idea to be mindful of that. If you aren't adding headcount, there's a ton of training and certification programs that are available that can help employees develop skills in a given field or help them gain that knowledge necessary for them to grow within the company. So by defining pathways for personal and professional growth and providing that training necessary to reach those goals, employees will be more likely to be engaged and continue with the company. So working to establish those programs and policies around them will benefit not only the employees, but the company as a whole. Wellness programs are another good option. If you can get those in place and help educate the team on it, that'll help drive positive morale. If the goal is increasing employee retention, take the time to create an understanding of what motivates your employees. Utilizing things like surveys, performance reviews, and check-ins can all help identify issues that may not always bubble up to the decision makers within a company. Even a new employee who's fresh in will have valuable feedback on the onboarding process, and they may have a fresh pair of eyes that can help see something that somebody who's been there a while may not even notice. Trends and feedback can also be an indicator of a bottleneck or issue that could be addressed differently. With 2 or 3 employees, it may be pretty easy to kind of check in with everybody every day. But as your company starts growing, you may not have that luxury anymore. But establishing a process as the company expands to have periodic check-ins can be hugely beneficial. One of the ones that we had at a previous company, we noticed that a particular business group was reporting higher rates of burnout on their quarterly surveys. Well, it was an indicator of possible attrition, which meant that we had to assess or adjust our headcount projections accordingly. It also raised a flag that, hey, maybe we should try to address this. So the manager started digging in, and we started looking for ways to mitigate some of the crunch that team was under. Ultimately, some additional headcount was budgeted for, and we're also able to reallocate some resources from a team that wasn't as stressed to better address the workload. On the following survey, we noticed a substantial reduction in burnout. Attrition rates are also another indicator, but by itself, that may not necessarily mean that it's employee satisfaction. It could be a multitude of things, whether it's the salary may not be aligned with the market. But if you start conducting exit interviews, it'll help you get a better idea of whether it's employees aren't happy, there are just better wages out there, things like that, so that you can start implementing measures to address the retention moving forward. Tying in with that, anytime that there's any sort of change in a company, it can be scary. People tend to get comfortable and they tend to enjoy being comfortable. There's hundreds of articles out there about various reasons that employees will be resistant to change, such as the fear of the unknown, mistrust, being comfortable in the familiar, etc. However, change may be necessary for improvement. While I was working on this, I was thinking back to when we had switched our internal HRIS to a new product at one of my old companies. So during the build up to the transition, my manager was always saying, the old system will never be more loved than the day after the rollout. Sure enough, as soon as we rolled out the new system, everybody wanted to go back to the old one. Despite the complaining though, the company had started that communication stream early, so we understood that the new system was going to bring a lot of features that would help make our lives easier. We'd received considerable training on the new system so that when it rolled out, we had about 95% of what we needed. The way it was structured and laid out was continuous communication, continuous training, so that when that day hit, even though it was a little bit scary, it wasn't as much of a nightmare as it would have been if they would have just flipped a switch and said, hey, here's the new system, have fun. Same thing could be said for other changes. So things with like mergers and acquisitions or organizational restructures. It's common for employees to fear losing their job. It's just the nature of how it goes. It's an unknown. They don't know what the new company is going to do. But if you start that communication stream early and let them know, hey, this is the plan, this is our vision, this is what we're trying to do, employees are more likely to buy into it, and they'll be more apt to cooperate and work with you as the changes occur. With open communication lines, both upward and downward, this will help alleviate some of the more common issues. And it'll also help decision makers maintain awareness of any surprises that may arise. So it's just a good idea, again, keep that communication strong, have a plan in place, and make sure that you can keep that communication stream strong. With that, I'll go ahead and pass it over to Amanda so that she can take over and run through a case study on a EEOC claim.
Thanks, Mitch. Okay, we've given you a lot of homework over the last half hour. Again, these are check-ins and things to keep in mind. So hopefully it hasn't been too overwhelming so far. But, you know, when we are talking about all of this, especially in a day like today, where we've come at you with quite a few tips or quite a few to-do lists, you want to circle back to why does this matter? And not just for the health of the company and the health of your employees, but a lot of times, whether we are talking here with you guys each month or on the calls, the policy, the actions, the decisions we make circle back to us saying to you, well, you can do that, but you might have a discrimination claim. You can do that, but you're really opening up yourself and you're increasing your liability. What's your risk tolerance? If you've called in, you've probably heard one of those lines before. But we thought that it would be helpful to spend some time and actually look at a real case. I know that I mentioned it was either in December or November that we have had more companies call with open EEOC claims than I have ever experienced in my career. And I don't say that to put anybody in a position of fear. It's just being aware. As we talk more about our rights, as that's on the news, as it's on social media, as people hear about big cases and how companies treat employees, they are becoming more aware of the process. They know that what the EEOC is, and they know more about their rights. So a lot of this is just catching up with that exchange of knowledge and just a more informed workforce. So the case that we picked out, which is a little tough because you can even pull $1 million cases, we wanted to focus on one that could be local for some of us. And all of this is public information, so it's not like we're sharing anything. This is not one of our clients. This is the case study that we went through. But American Piping Inspection, actually out of Midland, just had a case decided where they had to pay $250,000 on one case to one employee. So I'm going to deep dive into the facts with you a little bit so that you can see how something like this might happen. And that isn't that out of the ordinary. And then we're going to talk a little bit about, let's fill in the gaps about, from what we know about the EEOC process, what we think they're not saying could have happened. And then where do we go from here? What should they have done? What can you do? So again, company in this particular case is out of Midland. They've got offices in Oklahoma and Houston throughout, but this worker worked in Midland. This actually started back in September 2021. And I mentioned that because remember, with that much time, we're talking 15, almost 18 months between then and now, someone has been working this, whether that's been attorneys or HR people or managers. All that time, this one case took up time and energy and resources. So the initial charge, if you go back and look at the EEOC statement, is that the inspection services company subjected an employee to a racially hostile work environment. And the employee in question is Black. And that then the company fired him for him exerting his rights to file with the EEOC. So also a retaliation claim. So two big things there: hostile work environment, retaliation. So we're, for this specific example, looking at race, and then looking at both discrimination and harassment by those charges. So again, out-of-state company, actually based out of Tulsa, but operating here in Midland. The charge was violating federal law. And it was actually specifically mentioned that his supervisor was the one that created and condoned the hostile work environment. The employee alleged that this actually started on his very first day of employment. So I will say we don't know exactly how long the employee worked there. Some details, because this did settle, are closed. So we don't have all of the ins and outs. But keep in mind that generally when you open an EEOC claim, you are focusing or only allowed to focus on incidents that happened in the year prior to when the claim was made. So if the claim was made September 2021, and it was probably before then, but let's use that as the base date because that's what we know. He would only be able to look back until October 2020 and moving forward. So it had to be a fairly recent employee if he was citing that the harassment and discrimination started on day one. But what the EEOC charged was, again, the retaliation of him complaining eventually had him terminated, and then that there was the hostile work environment and discriminatory environment from the beginning. He allegedly, the supervisor, used racial slurs, not only to this specific employee, but to several other Black employees that were there on site. Supposedly he made racist jokes. He used names and slurs in everyday conversation. He did this not only directly to the workers, but in large groups. One example actually talked about some sort of company party when this was happening. So there were quite a few witnesses. But there were several people under the accused supervision that witnessed the incidents. So what did the employee do? How did they get there? So the facts that we know is that allegedly the employee started by talking to that supervisor, which is often what we recommend when you're writing a discrimination or harassment policy. If it's civil at that point, if there's comfortableness, to talk to the person that's offending you. Sometimes it's a learning opportunity. Sometimes you're able to come to common ground about what was really said and what we heard, because those things can be different. In this case, the employee felt like the supervisor just blew him off. He continued to use the language, continued to make comments. So the employee actually then went to the vice president directly and made his complaint. Again, we don't know every bit of ins and outs, but essentially no action was taken. No changes were made. The employee wasn't ever followed up with. Supposedly nothing was said or done that was documented to the supervisor. And then again, the jokes continued, the slurs continued. And then actually at that public gathering, the employee said that the supervisor, in addition to making these jokes, actually pretended to shoot at him with finger guns. And again, I know that that could go in a lot of different directions, but the claim here in this case was that it was done in a way that wasn't joking, but was actually a threat to the employee, and that it was made in front of other employees. So again, that employee felt threatened now at this point, on top of the other original feelings about the language and the treatment. So he goes back to the vice president. Again, no action from the vice president. And then from the EEOC stance and the employee stance, what actually happened, the only change after these complaints that were addressed directly with the supervisor and then twice with the VP, was that the employee then started to become scrutinized and watched. He started to be disciplined differently than other employees. So it seemed like they were targeting him. Now we're getting into that retaliation piece for actually making a complaint. So they are unequal treatment of employees. You know, if one person was not written up for being late twice a week, this guy would have been written up for being late. Just an example of the case. But shortly after that scrutiny that he felt was misapplied happened, he was actually then terminated. And if you have been through any sort of EEOC case where the employee files while they're still an employee, it can seem like an easier out if that person is not there anymore, but that's actually created quite a bit of complications for the employer, because then again, we had this retaliation piece versus trying to civilly work through it, even with the EEOC involved. He was fired, and now there's one more claim the employee had against the company. Again, this started way back in September 2021. When this happens, the employer is notified, the employee gets copies of everything. The employer has an opportunity at that point to write a response to whatever the charge statement is. They do get to see the exact language and see exactly what the employee is saying happened. Both parties at that point have the option to agree to mediation. Mediation can occur by a third party. So this would be independent. The process is supposed to be confidential and in no way actually affect any future lawsuits. So these two individuals, or the employer and the employee here, actually did go through that mediation process. And if you have ever been familiar with that, or we work with employees that are either in that process or avoided that process at some point, mediation with the EEOC is actually normally pretty successful. About 70% of their cases are settled through a mediator before actually that actual suit is filed, and the full charges against the employer come through. So they tried, which means they did back and forth, they introduced evidence, they introduced their cases. They weren't able to come to an agreement with the mediator. Okay, so at that point, it goes back into the EEOC charge, and they pick back up, and the EEOC investigates to see whether or not a suit should be filed. So in this meantime, I want you to be thinking about all the things behind the scenes. If an investigation hadn't been done, one had to have been done by the employer. They may have done it internally, but they may have had to hire someone else to come in and do it. If they didn't document appropriately, they're having to go in and document what they reasonably can document from that phase. Again, this becomes a big expense, not only for the time involved, but obviously the direct monetary charges as well. So they're having to go back and essentially build a case, and the employer can respond to the charge before the suit is actually filed. And again, these are quite detailed. A lot of times you're pulling in legal precedents to that. I have seen some as short as a paragraph going through. I think we told you last month one that Mitch and I and the HR team worked on, I think came out to 84 pages to try to make the case against one employee's claim. So again, it can be quite time consuming. It can be quite a big process to fight these. But again, if you are in that position as employer and the mediation didn't work, you don't really have any other options at that point. So this employee was not only seeking back pay in the suit, but also punitive damages. So they not only wanted the pay from the point at time which they were terminated to when the case was actually occurring, they also wanted punishment or damages from the employer as well. Case went on. EEOC's stance was employers have the legal duty to take care of prompt corrective action, to investigate any claims, which is where the EEOC is always going to come from. If race-based conduct arises in the workplace, it should be investigated. Should training need to occur, should changes in policies or behavior need to occur, that should be done promptly. And again, in this case, we knew of at least twice where it was elevated to the vice president level, and at least once that it went to the supervisor. So in this settlement, they ended up saying that not enough was done when those complaints were made. So EEOC comes back and reminds, in their summary statements from this case, you've got to make sure as employers that your supervisor understand these policies. It's not just a page in your handbook. It's not just a video or a quick review on people's first day, but that we understand what discrimination and harassment actually are, what that looks like in reality on a day-to-day basis, and what to do about it, which very honestly is more challenging than it seems. Because if you think about all the information a supervisor gets in a day, all of the little petty back and forth between employees to things as big as this and beyond, as an employer and supervisors have to go in and have that checklist of, okay, is this something I document? Is this discrimination or harassment? There's a lot going on day to day about when it's time to do a formal investigation. Again, EEOC's statements after the fact, just wanting to make sure employers are notifying and making sure supervisors are trained that racial slurs are not acceptable in the workplace, and that we have the duty to provide all of our employees an environment full of discrimination and harassment. So again, settlement went through on the side of the employee. So this didn't actually go fully to a suit or to a court proceeding in a traditional way. The employee ended up getting several different things, and this is not unusual based on what we see. It's normally not just one punishment or one action item. There's normally a laundry list. In this case, the employee got that $250,000 that we talked about. They also came back and said that they had to do a 3-year review process where the EEOC would be monitoring and working with the organization to make sure that the discrimination and harassment policies and procedures were becoming stronger, and that everything else that was required as a part of this settlement was actually being implemented. So ongoing coverage, ongoing input from the EEOC. So this didn't just end at the beginning of this year. This is going to be haunting the employer for the next 3 years. Other things that came out of the requirement after the money was a revision of the employer's actual discrimination policies. And again, that's one of those things. It's really easy. We touched base on this, Mitch and I both, that it's easy to forget to go in and change a policy if it doesn't feel like it's not working. If it's not something that's come up before, why do I need to change it? It is a good idea to go in there and make sure that there's a clear policy. Who should employee tell if something has gone wrong? If that person doesn't respond, who should they go to next? Do you have an open door policy? Who's going to be the investigator? These are all things that you need to be thinking through in that what if situation. So then again, ongoing personnel training. So that would be both for the employees and for the supervisors. In the few cases that we have dealt with the EEOC, the training aspect has come out of every single one that I have personally worked with. Even if something like the policy wasn't required to be rewritten, training was always required. And a lot of times it was for multi-year trainings. It wasn't even a one-off. It was every single employee, every single supervisor needs to have a 2 to 3 hour training. And oftentimes they had to have that training for anywhere from 3 to 5 years. So keep that in mind as well. If you don't currently have a training in place, it might be easier to do those things on the front end than on the back. But so they had to require personnel training, and then they also had to require that the EEO notice posters and notices. So again, that tells you that those probably weren't up to date or are visible for the employees, but making sure that they had the discrimination notices. So all doable things. And again, that ongoing review from the court for the next 3 years. So they're going to be highly involved in the organization. So after the monetary one, it's mostly the administrative side, a lot of training, a lot of policy changes. But again, that big amount of money for an employee that really wasn't with the company for very long, and a situation that could have been avoided. The initial incidents, maybe they couldn't have been avoided, but the fallout, the ongoing, expense and time and energy that had to go to settling this, certainly if this was handled differently, could have been minimized. Again, even as I mentioned before, that retaliation factor coming in. Once that claim was made, it might have been a better idea to really make sure that this employee was being treated equally versus trying to get rid of the troublemaker and fire them. Because again, that drew in that retaliation piece, which is one more charge on top of the discrimination and harassment. Things to take away from this. What did we learn? A few different things. And I will say one piece of this that I'll point out and is not atypical for the things that we talk about every month is it's hard to define exactly what retaliation looks like. Like so many of the HR legislations and regulations, we're given this language, but we're only able to see what the court meant by that through case precedents. So even though there's a definition of retaliation, what does that look like on a day-to-day basis? Again, the EEOC doesn't tell us exactly, but they give us these hints and reminders of what adverse employment actions might look like. So as I'm going through this list, try to think about your own policies, your own procedures. Think about those cases where maybe nothing huge has escalated, but in more workplaces that I have personally been in than not, there's always someone, whether it's the person that, is a little too bold with their comments to certain employees, whether it be sexual in nature or just to women. There's that person that makes those jokes that go a little bit too far. But a lot of times we don't deal with it and we just learn to ignore them, or we say, oh, that's just so-and-so. These things can very easily escalate. And a lot of times what I circle back with employers and say is, this may not happen exactly in the moment. You may think that the guy laughing at these jokes or that's in your inner circle is never going to file a claim against you. Well, things change, and remember that people's personal health and welfare, they're probably going to put ahead of your business. So let's say they're terminated for something else entirely. They could always come back and remember some of these situations. And if it was within the last year, that might be the point at which they file that claim. They might file it for things that you never thought that they would talk about. Maybe they even made the jokes as well. But if it was never addressed and went on, especially like in this example, again, it ended up spiraling. So a few of those adverse employment actions to watch out for in your day-to-day happening. Any sort of work-related threats, okay, that seems pretty obvious. But the warnings, the reprimands that happened in this case, making sure you're not actually targeting or treating that employee differently than others, which sometimes is very honestly challenging when they're frustrating you. It's easy to point out the negative things someone is doing when they're that thorn in your side right now. But would I respond to another employee in the same way? That's what you've got to look at. It could be whether their performance review scores were lower than what maybe was warranted. We just touched a bit based on that, or maybe you just did performance reviews. If you didn't go through and check and see if any glaring, obvious higher or lower scores went through, that's something you might want to go through and do some retraining on for next time. Another action could be transferring them to a lesser position or even in a less desirable workplace. It could be making false reports to the government about this employee. It could be filing civil action against them. It could even just be threatening them with reassignment versus actually doing that, or scrutinizing them more closely, like we saw in this case. Last couple of things about what retaliation might really look like. It could be removing them from their supervisory responsibilities. It could even be trying to discourage them from filing a claim. Let's say you have gone through several of these steps that we've talked about. You have a procedure in place, you are trying to investigate and mediate, but you're trying to talk them out of actually calling the EEOC, which is their right. If it is severe or pervasive enough that it creates a hostile work environment, then they're going to consider that retaliation. Another lesser known way would be re-verification of work status. So this would especially come into play if there was an immigration case or if it was focusing on someone with a different type of employment authorization than a standard practice. Maybe it's somebody who only comes up every 2 or 3 years. If you're focusing on that unfairly, that could be considered retaliation. Blocking any sort of grievance, union grievance. And then the last one to keep in mind would be punishing other members of the family. So taking action, maybe it's not only demoting or moving that person, but taking it on maybe another person within the organization that's related to them. So what could they have done differently? Again, it's easy for us after the fact, but set yourself up for success. Go in this beginning of the year, like Mitch and I talked about, this is the time to start your year off right. Do you have a policy? Is it specific to tell people what to do? Plan for worst case scenario, because even though it feels like, 1% chance that this could actually go to suit, again, more and more employees are becoming aware of their rights, and we are seeing more of these charges faced. And even if it doesn't go to lawsuit, it can absolutely still take a lot of your time and energy. Another thing I would really bear in mind is a lot of times employers like to have their policy and they want to leave it at their discretion. I would caution you that a lot of times discretion can equal discrimination, and that may not even be your intention. It might not even be something that you intentionally do, but you're favoring an employee that's been with the company longer, but then you treat the next person different. You really have to look at those policies, that you have any sort of discretion outlined, and make sure that that's not setting you up for a discrimination case. If you don't have an open door policy or something similar to that, it might be something you want to add in. You never want the employee to be able to say, oh, well, it says to go to this person and they weren't available, so I didn't report it. I let it keep going. They could have had more regular ongoing training. You know, we know from this settlement that they didn't have the posters up, they didn't have a solid policy, they didn't have training in place. But again, discrimination and harassment training shouldn't just be a page in your handbook. It shouldn't even just be a 1-hour training when someone starts. That's maybe a video from 30 years ago talking about discrimination and harassment. Ongoing training about what this could really look like at work. Reminding not only your supervisors, but your employees that if they see something, they need to say something. And ultimately just raising the standard and expectations for yourself. Again, it's easy to try to hope that poor behavior will resolve itself or go away. But that can absolutely be very costly to your organization, like we saw in this particular case. Hopefully that was interesting. And if you have any questions, not only about the discrimination or race case, but anything with Title VII or EEOC, again, we're always here to help. We appreciate you, and go back to Elizabeth.
Thanks so much, Amanda and Mitch. Hopefully everyone doesn't have deer in the headlights. But like you were saying, it's better to prepare and, you know, take the time to get those policies and things in place prior to a catastrophe taking place. So a friendly reminder, as a client of ours, you have complimentary services with Ironwood. So if something would arise, or if you are indeed feeling the pressure, like you don't have the policies in place and you don't have certain things that were discussed today in order, please feel free to either reach out directly if you don't have your paperwork done, or you can reach out to Amanda and Mitch. Wishing you all a wonderful week, and I will see you all back in February. Thanks, guys.